All right. You are live.
Welcome to the Monday, February 24th, 2025 Board of Supervisors work session. This meeting is now called to order. Ms. Whitten, we now conduct the roll call for the board.
Supervisor Day.
Here.
Supervisor McDaniel.
Here.
Supervisor Lyons.
Here.
Chair Ayers.
Here. Review of COIA and FOIA. Mr. Dryden.
I'm sure everyone's been excited, looking forward to this presentation. I want to go through, there's a reason for doing this. Hopefully I can advance this. There we go. Part of the reason why I thought it was important that we go through this and do it in a public forum was, one is just not only to advise you on your obligations under COIA and FOIA, but to also advise you as to what the county is doing to comply with COIA and FOIA, so you understand our procedures. And I think a third benefit of doing a public forum is that it will allow the public to understand what we're doing and have a record of that. We don't have anyone in the meeting today, but I think if we continue to offer that to them. I will tell you that a much larger percentage of my time than I expected is spent responding to COIA and FOIA inquiries from the public. And and I anticipate that will continue because many of the groups in our county and outside of our county are using these laws to gain information and to challenge as to whether or not we're properly following these rules. So that's one of the benefits, I think, is for the public to be able to understand that we indeed are using our best efforts to follow these rules. And from my experience being with the county now for almost a year, I've not seen anything to make me think that any county employee or officer is not complying with their COIA and FOIA obligations and not using every effort to do so.
Mr. Dryden, would you please use the mic a little more? My hearing is a little, ears are stopped up.
I'll try to speak
and
louder.
this will be online as well.
Yes.
For the public to refer to it. Okay.
Yeah, they can refer to this. And I think hopefully when people call me on this, which they will, I can say, well, here's something that we have done. I will reach out to all of you individually, or you can come back to me in a group as to whether or not we should do this on an annual basis or a biannual basis. By law, you're required to get COIA training once every 2 years, which I believe you do online anyway. But this also would qualify for that training. But I'll reach out to see whether you believe it's in best interest to continue this on a regular basis or just do it as an as-needed basis. The purpose of FOIA is generally the main purpose of FOIA is to make sure that public business is conducted in the public to the extent it's not. There's no reason for it not to be. Under the FOIA, we're required, under the Freedom of Information Act, we're required to broadly interpret any obligations we have under that, and any restrictions or exemptions are to be narrowly interpreted. There's no record is supposed to be withheld, and no meetings are supposed to be closed unless there's a specific exemption allowing that. One of the more interesting, one of the areas which I believe that the FOIA requests will continue to grow, and we will see more and more of them in the future. I believe that we should prepare ourselves that FOIA requests could be used also for purposes of looking for litigation opportunities to challenge the county or the activities that we've done. I believe we've had several meetings already since I've been here where we've discussed in depth FOIA, where some of the members of the public has challenged whether or not we complied with it. And luckily, in almost every situation, not luckily, I think purposely we have complied. So any challenge we've received so far, I think we've been able to answer appropriately. One of the areas to consider, and we'll talk about a little more in detail, is the use of email and personal phones and how that applies to our FOIA obligations. And I've talked to most of them county employees and officers about that, and will continue to do so. Everything that is produced in the conduct of doing business, public business, is a public document. And that's the general way to look at everything that way. And that means any writings, it means numbers written down, whether we write down, on paper or electronically, that is a public document if it's tied into the conduct of public business. And then also includes any drafts that we do. And those are also public documents. And you can delete drafts if they are don't have any additional info. For example, if you prepare some drafts about things that you would like to say, and you prepare a final document with things which you'd like to say, if the draft that you prepared does not contain any additional information, that draft doesn't have to be retained. However, if the draft contains notes on it, which could be considered additional information, if they're done in the conducting of public business, you have to maintain that draft. So it's not as simple as saying that I have another version of this, so I can just delete it. We have to maintain them, and out of habit, it's probably best to maintain all documents prepared in the conduct of public business. One of the bigger areas to consider, and one of the areas which applies to you more personally on this, is the use of your personal phones or the use of personal email in the conduct of public business. So, and that also means that if you receive a text from someone in the public to your personal phone, that is a public document. If you respond to that individual or anyone else or even amongst each other using text on your personal phones or using personal email addresses, those are anything written in those and on the phone or in the email are public documents and have to be maintained, and it's against the law to destroy them. Given the fact that I believe that many of you and many of our employees actually use personal phones in the conduct of personal business, of public business, it's my advice would be that if you receive texts that you think are probably public, that may be public related to the conduct of public business, that you forward those texts to your Rockbridge County email. If you forward them to your Rockbridge County email, then you don't have to maintain them on your phone anymore. If you don't, you have to maintain them on your phone. And on top of that, that phone would also be subject to discovery if we were sued. And that means that you would have to provide your phone to a technical expert who'd record all the information on your phone, and then they'd provide to the other side who could then search through it using approved keywords. So what I personally do is I have a county phone for use of for county business, but I know that's a pain. So just consider that, realize that if it is on your personal phone, that we have to be careful with that. And if it comes to litigation, the information discoverable in the litigation is much broader than what's discoverable under FOIA. So if you can keep those things in mind, that's important. And again, don't delete things on your phone or from your personal email if it has anything to do with the conduct of county business, and you have to broadly interpret that. So even if it's your personal opinion on a particular county matter, you need to assume that was done in your role as a elected official. And again, if you have any questions or comments, feel free to stop me at any time. Who has the right to make FOIA requests? Under the Virginia Freedom of Information Act, only citizens of Virginia have the right to make a FOIA request. And then also, news organizations that either publish or broadcast into the Commonwealth can also make FOIA requests. That's actually, we have received FOIA requests from people who did not identify themselves or did not identify that they were citizens of the Commonwealth. However, organizations that send out FOIA requests on a regular basis, which several do, for example, we regularly receive FOIA requests for the salary schedule for all county employees. And that's and for budgets and for other things. And there's not-for-profit organizations who track that throughout the country. And if that request comes from outside of the Commonwealth, we don't have to respond, but these organizations hire local people who would send those requests out. So for most cases, they do provide a local address. The FOIA Council, which was set up in the Freedom of Information Act legislation, even recommends that even if a request comes out from someone outside the Commonwealth, that you respond anyway. We generally have not rejected any responses. However, if we receive a FOIA request and the person does not identify themselves, we can ask for their name and for their address. And so what I've recommended to the employees in the county is that they request that information if it's not present, and our obligation to respond doesn't start until we receive proof that individual is a citizen of the Commonwealth.
Do we charge Those response?
We can, and that's one of the things we're doing. I give an example, which has happened just recently. I received probably one of the broadest FOIA requests I've seen since I've gotten here for information pertaining to the opioid settlement. So there's one of the defendants is now sending FOIA requests to local governments throughout the whole country, trying to get as much information as they can just to see whether or not each of the local governments properly followed procedure. So we basically have a FOIA request for pretty much anything at all dealing with opioid litigation, opioid settlements, any information received and we sent out. Much of that would be covered by attorney-client privilege, but because I would have to individually review every single one of those documents, I estimate it probably could cost upwards of maybe even $1,000. So when they sent in the request for that, it came from a large law firm, but when they sent in, it was sent by one of their associates who lives in Virginia. So when I responded back to them and gave them the quote, and then I responded back to them, which I have the right to ask for a deposit, because I said that, it's anything that costs $200 or more, we could ask for a deposit before we actually start the work. And now I didn't do that to be difficult. It's just because it's not the law firm that has to pay the deposit. It's the associate who or has to pay for the cost of it. It's the associate who's doing the requesting. So I figure in that situation, we should at least ask for at least the $200 just to make sure that we can get some of it. But yes, it has not been our practice to ask for cost reimbursements as much as we could do it. But I've been encouraging people to use that. It also, especially as our FOIA requests increase and more of time is taken up doing that, that it's important that I think that we ask for that. And it also would help so people don't just come and make, like another example would be, we had a very broad request for information on solar approval of the solar arrays in some of the areas that we have here. And so I went back to the individual and said, we have to, it's probably going to cost us more than $200 and you're going to need to pay for this. And so that individual decided not to proceed with it. So I think it does help to stop some of the fishing expedition style of things that can be done with FOIA. And it does make sure that the people who are doing this are really serious about it. They're not just making requests. And so it's important that we comply with it. We do have in our policy, we do not charge for the first hour, which I think is good. I think that shows that we try to be accommodating. And but we do have in our policy that we charge 5 cents for every printed page and 17 cents for every color print that we do. Plus, we charge the hourly rate of any employees that are doing the work.
Can I ask a question?
Sure.
How much of these documents are already online and we've provided, as part of our reports?
Well, quite a few of them are, but we can't use that as a reason for not answering a FOIA request. So, yeah, no, but that's a good point. Quite a bit of it, the information is online already. Some, from the minutes from meetings. But if we're asked for, to provide resolutions from a particular meeting that pertain to a particular issue or portions of the minutes, we can point them to where that is, but we normally, what we do is we'll go and get the actual information and provide it to them either electronically or by printout, depending on what they request. And that's one of the issues too is that if they ask for something where we don't have a record, for example, we did receive requests for some of the economic interest disclosures that you file. And we received that request on February 2nd or something. And we actually have 6 weeks from the time that it's filed before I provide it. So there is no document and we have no obligation to provide it until it's actually prepared. If verbal conversations that you have, we don't have to write things down. If we look for something and we don't find it, we don't have to make a document. Even if we know what that information might be, we're not expected to write that down, and nor should we be making documents to qualify. It's only FOIA requests only apply to documents, even though the definition of document is quite broad. So the way some of the issues with requests is they do have to be specific enough so they can't say I want any information on animals. that would not be specific enough. But if they ask for specific information on the SPCA and any documents we may have with them, we need to respond to that and provide that information. And one of the important things to remember with the Virginia FOIA is that we cannot set a procedure in place saying you can only file a FOIA request in this particular manner. Anyone could call up any county employee and say, I want this information, and that is a FOIA request. They could stop one of you in the street. They could stop me in the street and say, I want this information. That's a FOIA request. So that makes it difficult to track, and I'll get to what we're trying to do with this. But any request that is at least has a certain level of specificity that we can at least understand what they're asking for.
Verbal request?
Verbal requests. Yep. So if someone asks you, if they walk up and knock on your car door and you open the door, I guess we might do that in the county here, and ask for something, that's a request. So what I do as part of my practice is because people will ask for things all the time, and I will clarify, I'll ask, is this a FOIA request? And so I give them the opportunity to say yes. And sometimes they said, no, I'm just kind of interested. And I said, well, you can stop by the office and talk to me if you want to. If you want to do as a FOIA request, then we're obligated to respond to you within 5 days. So, but it's so I would suggest also that if there's a question as to whether or not it's actually a FOIA request, just ask them, is this a FOIA request? And if so, then I'll get in a minute into the procedures that I would ask each of you to follow, and procedures that we're trying to implement at the county level to make sure we can track these. And it said the requester does not have to say FOIA. That's one of the points I'm hearing. They don't, but I think we should always ask back, is it a FOIA request? Because sometimes they might just be, in general conversation, might say something that sounds like it's a request, but you'd want to clarify it. And it doesn't matter why they're asking. They can ask for any reason, whether we agree with them or disagree with them, we can provide it to them. If they think aliens are invading and they need to get information on that, that's a legitimate reason for us to provide for them. We have 5 days to respond. That's 5 working days, counting from the day after we receive the request. And if we can't do within 5 days, we are obligated to request an additional 7 working days. If we can't do within that period of time, we can go to the court and ask for an extension, or we can come to an agreement with whoever's requesting for whatever period of time we're allowed to do agreements. If we're asking them if we want to clarify whether it's a FOIA request, such as sometimes I'll get emails and I will send back, is this a FOIA request? And I don't start the time until I get a response back. We are required, if we believe that there's going to be a fee associated with it, to let this requester know what the fee is. And until they respond that they want us to proceed even with the fee, then we are not required to, the time doesn't start till it doesn't tick until they respond back. If we request a deposit, the time doesn't start until they respond. Now it says until they respond. It's not clear in the document where the 5 days start when if the response is receiving the check, or if the response is saying, yes, go ahead, I will send you a check. And I haven't found a clear answer for that one. So I'm taking the conservative view, which means that that as soon as they respond and say, yes, I will send that, and I still want the information, that we start the work on it. It seems to undermine the whole purpose of getting a deposit, but that's the way the statute's written. It says, it uses the word response. It doesn't use the word receive the funds. If we don't respond within that period of time, that's considered a denial of the FOIA request. And if it's not done appropriately,
Even if they have not paid their deposit?
Even if they haven't paid their deposit, because of the way it's written the word response. It's not written it says that we're not required to ask for the deposit, but we're allowed to ask for the deposit. You may ask for the deposit, and that the 5 days tolls until you receive a response, which does seem to undermine that. But frankly, this was the first time I've asked for a deposit because for the opioid issue, because it was from somebody we didn't know and couldn't track down as easily if we had to. What we're required to do once we receive, these are actually by statute the 5 things that we're allowed to do once we receive for requests. We provide the requested record. We need to let them know that they're requested, or we can let them know that requested records are being withheld in their entirety, that they're being redacted, in part withheld and part provided. that there is no such, we have none of those records, or that we need the additional time, which is additional 7 days unless we get an order from the court. If we do fail to provide the information when required, then the individual, which I'll get to the fines here in a bit, but the individual who failed to do so is personally liable for a fine for failing to comply with FOIA. This is the stuff we just talked about a minute ago. So we can't charge more than our actual costs incurred. We can't put overhead expense on top of it. So if it costs, that's why we say 5 cents per black and white copy and 17 cents for color, because that reflects generally our costs. And if they don't give any direction on how to determine the hourly rate for individual employees. I've read some places where they said we can count the cost of benefits. In other words, the additional cost the county has to provide, which is usually 20% plus on the top of salary. Some places say no. So when I determined, for example, what I expected my cost would be to review the documents in the opioid FOIA request, I just divide my annual salary by 52 times 40 to get what it was. And so that was, even though we maybe be able to charge more, but I think that's still, it's better. It's better to charge, my view, until there's a clear answer, it's better to charge the lower end, because we couldn't be viewed violating FOIA that way. If they don't pay their bill for 30 days or more, and this is not tied to the deposit, this is tied to if somebody has asked for a request several times and they have an outstanding bill that's more than 30 days old, we don't have to respond to any of their future FOIA requests until we collect. However, if they have several outstanding bills and none of which are 30 days old, we still have to continue responding. Things which are exempt from FOIA, this is just a short list of them: personnel records, attorney-client privilege, legal memorandum, which is legal work product, things that the attorney prepares in providing advice. Contract negotiations, we don't have to provide documents pertaining to them, but there are some documents that we do have to pertain. Once, for example, procurement, which is if we have a procurement contract, we had one of the contractors that we recently signed a contract with wanted to withhold their price and from public release, so it wouldn't be subject to FOIA. And we had to explain to them, no, that's under the law. It's actually specifically that price is not a covered, is not a protected issue. So you'll find quite commonly in the procurement area when we put out RFPs that the loser of the RFP, or even sometimes the winner, will ask for all of the information provided from the other bidders, so they can have an understanding of what their competitors are bidding. And the only thing they're allowed to protect is business secrets. And they have to do it they have to provide that, they have to send to us highlighting in the documents what they want to protect, and they have to do it in a narrow fashion. So, and if we don't, and it's not there, it is our obligation to determine, even if they ask for something to be protected, if it's not actually legally protected, we have the obligation to release it anyway. So we have to be aware of what can be released and not released. And so I work closely with Amy, who is our procurement officer, and what we release and don't release.
I'm glad to see accounting numbers are exempt.
Well, yeah, I think that's actually that would be like account numbers. So it's,
I know.
So anyway, yeah. So we don't have to, and also your individual signatures we're allowed to block those out. So, which I'm not sure, because some documents, such as resolutions, where the chair signs them, or that is not, can't block those out, but in other situations we can. Public meetings are this policy of FOIA is that all meetings of public bodies must be open unless they're strictly allowed to be closed. It's important. I think we've already gone through this since I first came here, but a public body is any body, authority, or any subdivision of the Commonwealth that is conducting public business is a public body. That also applies to entities who receive funding. So I think I went through some of Vicky's negotiations with the SPCA, for example, on the contract. And one of the big issues that was there is whether or not they're subject to FOIA. I think Vicky was completely right. They are subject to FOIA because they receive a significant amount of their, well, the majority of their funding from a public body. There are some arguments that they made, but that would be an example where they would be required to comply with FOIA, at least in their activities which are funded by the county. And that's important because they're actually in that situation, they're engaging in a public function. And so they are doing a function that if they didn't do it, then we would be required by law to have the sheriff's department or someone else go out there and or whoever, it's not catch the animals, whoever would set up some entity to receive stray animals. That's an obligation that we have as a county. And so so any entity that we provide funding to, the drug courts, but I think they're a public body anyway. But some of the other funding that we have provided, if it's the majority of the funds that they receive and that they're performing a public function, then they'd be subject to FOIA. Another important issue is that, which I think we've fixed that, but committees are subject to FOIA and to the public meeting rules. So now we do provide notice for all of our committee meetings. Meetings include work sessions. It's any time that a quorum is gathered to discuss, to conduct public business. Quorum is the majority of the members. If it's a committee of 3 people or a committee of 2 people, it's always going to be 2 people. And one of the key things here is that the purpose of the meeting must be to discuss public business, and public business is broadly defined, but that you will generally receive advice from me and probably have from other lawyers too, that you want to be careful in gathering together in public with more than 2 of you. In theory, all of you could gather and have dinner together as long as you don't talk about public business. That's not a violation, but generally it's advised not to do that just because one, appearances, but number 2 is that it's pretty hard not to say something that could fall in the category of public business. And if all of you do gather together, or if 3 of you gather together, then that would be considered, and do talk about public business, even the smallest degree, that would be considered a public meeting. You would be required to keep minutes of that meeting, and it would be in violation of the notice requirements. But it is, if you do run in, 3 of you do run into each other at Walmart, that you don't have to run away. I mean, as long as you don't discuss public business, it's fine. You can, so that is the protection there. Meeting exceptions, we just discussed those. Most of these ones are applied to employees, and then public. The other exemption, which I think we discussed when I believe it was the governor that came to Buena Vista to talk about things that but at any rate, you're allowed to attend public forums together, and those type of things are not considered public meetings, unless you. The one thing to keep in mind, even in those situations, I would still advise that you don't sit together, just to avoid the issue of appearing to discuss public business. So no more than 2 sit together. Notices it's required when you have a public meeting that we have that notices are made to the public. Notices that we are required to have the 3-day notice, but then there's notice requirements under various different statutes for different things. Meetings must be open to the public. As a practice, we usually keep our door open, which is good practice. That's not necessarily required by the law. We could close it, but by keeping it open, there's no question whether it's public. And sometimes we do close it and put a sign on there, and that is not a violation of FOIA. Anybody who comes in these meetings is allowed to record it by any means that they have. However, if they're disruptive in their recording, we can ask them to, for example, if they want to walk up in front and take pictures, we can tell them that you need to stay back. That's allowed. And you can ask them to leave if they're continually disruptive. However, we cannot send somebody out of a meeting just because they are recording. That they're allowed to record. Minutes are required for any open meetings. We don't take minutes in closed meetings. And you're not required to take minutes in committee meetings. That's not required. And the key I put in there, unless the majority of board members are present. So, if there's 3 of you in the committee meeting, then that would be considered a board meeting. And that would be more problems than just the minutes, because we should have noticed that meeting as a board meeting, not just a committee meeting. 'Cause, 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 'cause In closed meetings, I think we understand pretty well what we're required to do in closed meetings. That we have to state the purpose for the closed meeting. It has to be stated clearly and specifically, and then we have to follow the proper procedures of going into closed meetings and coming out of closed meetings. Closed meetings have only certain things which are allowed to be discussed during those closed meetings, which and Vicky did a really good job with us in preparing the forms that we use for our closed meetings. So I think I don't think there's any issue that we have in the procedures that we follow now. You can invite, as a board, you could invite anyone you think necessary to attend a closed meeting. However, you're able to exclude anyone you want to also. At the exclusion of every closed meeting, you have to have the vote to come out of it. Failure to vote to come out of it, there's actually a penalty attached. That's $1,000 penalty if we don't properly come out of closed meetings. Difference is that it's not a personal penalty. That would be paid by the board of supervisors, not the individual supervisors. These are the issues that can be discussed during closed meetings. I think we've talked about some of those before. And they're not all of them. There's other ones, but these are the most common ones. Voting, any vote on any public business has to be, votes on public business have to be conducted in the public. So during a closed meeting, we cannot vote on that, though we can take straw polls to see what people are interested in. However, when you come out of the meeting, you'd have to vote on whatever matter you decide during the closed meeting. And as we discussed before, closed meetings can only discuss the issues that were the reason for we went into the closed meeting. And I think overall, we're pretty good about that. Electronic meetings, we've gone over this quite a bit already, so there's no reason to go in much detail about it, but there are 3 types of electronic meetings that are allowed. One is for remote participation, which the board has adopted a policy for that, and is now required to do it annually. All virtual public meetings, however, the board of supervisors is not allowed to do this. Some of our other entities, boards and commissions can, but the board of supervisors is not allowed to do that. And then if there's a state emergency declared by the governor or by the local government, then you can have a virtual, a remote meeting. Remote participation, we've talked about that before, main thing for temporary permanent disability, conditions that prevent members' physical attendance, medical conditions of a family member, if you're the principal residence is more than 60 miles away, or you can have up to 25% of our meetings per year. The individual can participate remotely if they want to. However, per our policy and that's per the requirement under statute, board members who want to participate remotely need to let the chair know beforehand and receive permission of the chair to be able to do so. And the chair is not required to grant the permission, but would have to have a reason not to do so. If we violate FOIA, there's the main avenue to challenge this is by court enforcement. One is a petition for mandamus, which is mandamus is to have the court order us to do something that we're not doing, or an injunction, which is the court to order us to stop doing something that we are doing. They're required the hearing. Anytime this is brought onto the court's calendar, it has to be done within 7 days, which is a very quick procedure because normally civil actions take months to get on the court calendar. If the petitioner wins, then we have to pay all the costs associated with it. And we also bear the burden to prove that we are right, that we did not violate FOIA. Violations, if there's a willful and knowing violation, the first offense is an individual fine to you or to any members of the county of $500. It goes up to $1,000, then $2,000, all the way up to $5,000 for subsequent offenses. If we destroy or alter any public records, there's $100 fine attached, which isn't that much, but there's also criminal sanctions that could also be attached in addition to that. And then the improper closing certification of closed meetings, that's $1,000, which would be paid by the public entity. Our internal FOIA team is Heidi Hoke, is our FOIA officer, and she's supported by myself and Stefan. We do have a dedicated FOIA email address, and we encourage people that come in with FOIA requests. For example, when I get FOIA requests, if they're over the phone or given to me in person, I will, as practice, I will send an email back to them saying, this is my understanding what your request is. And I will seek for them to confirm that. And once they receive the confirmation, I treat that as the beginning of the FOIA request. However, If I don't receive confirmation, I still will have to respond in accordance with that. I can't force them to use the email to respond. And I do ask them to. I always will put our CC our FOIA email address that we use, and that copy goes to myself, to Heidi, and to Stefan, so that we all receive that. We do try to do periodic training to department heads. Heidi asked that I help with training this coming department meeting to talk about, and what we're trying to encourage is that all department heads share with their employees that if they receive a FOIA request, any request is a FOIA request, and that they follow the similar pattern to put that into email, or to let Heidi or myself or Stefan know that they've received it, and then we would send an email out to confirm that that's the request. The reason why I'm encouraging to do emails is because without that, there's no way for us to track the FOIA requests that come in and to show that we have complied with it. And so if we're ever challenged saying that if somebody, and this could happen, if someone comes to me at Walmart and says, I want this information, if I don't write that down, I forget about it. And then 5 days later, they said, how come you haven't responded? I've violated FOIA. And I would, and the $500, if they go to court over it, there is no discretion for the judge to impose it. The judge will impose it just by the fact that I missed those 5 days when I was the one that should have been responsible for it. I would be, judge has no discretion to not impose the $500 fine on me. And so that's important that we get things written down so we can track it. And I think it's also important for the Board of Supervisors for you to understand the volume of FOIA requests that we receive, and that to show that we are doing what we're supposed to be doing. That's so we're working on that, and I think we're doing better already with that. But individual employees, the community development department, for example, gets quite a few calls asking for information, and I think they're working hard to make sure that that stuff gets recorded.
Who's responsible if somebody comes to me and says, I want this information from you?
Yeah.
Well, I don't have the information. I'd have to go to one of you to
Yeah.
get it. So who's responsible for replying?
And that would be the custodian of the documents. And so you are only responsible to make sure that you pass that on to, in this case, Frank, just to Heidi. She's the one to pass it on to. You could pass it on to me or Spencer or someone else, but it's Heidi, it needs to get to Heidi. And then once that happens, Heidi's job is to identify the custodian of the document, and after that, you have no responsibility. It's now the FOIA team's responsibility, and the custodian of the document would have to. So quite a few of it would be to Spencer because he's the clerk. So quite a bit of that would go to him. So anything dealing with minutes or other things that would go to Spencer. Procurement stuff would go to Amy. There's budget things would go to Ashton. So legal things would come to me. So it all has the place where it falls under.
But the time, if someone asks Mr. McDaniel on the street, and it takes 3 days to, not that this would, because we know how prompt he is, but if it did, if I didn't answer my email in 3 days, I'll use myself as an example.
Yeah.
Then the clock is ticking, and then I pass that on to Spencer, only giving him a day or two. So the point is that we need to.
Yeah, we should
make
do it
sure we
promptly.
do those very promptly.
Yeah, and it's hard to do when it's not, it's hard to put a system in place when you can just ask on the street for it. But yeah, we'd encourage you to let us know as soon as possible. In that situation, we would probably go ahead and ask for the extra 7 days, which we're allowed to do. But if it goes beyond the 5 days, then we've actually violated FOIA. Now, most situations, I think people would be understanding. We can call them on the phone or send them an email, and they say, okay, we'll give you some more time. But in theory, they could bring us to court right away, and we'd have to pay the cost of that.
Is it wrong when somebody asks you verbally, you say, okay, it is a FOIA, yes, okay. Send me an email as well. I mean, can you say
Oh,
that?
you can ask for it, but we can't say that the FOIA request only, even though I, as a policy, wait for the response to come back, and maybe that's not being as conservative as I normally am, but the verbal request is the FOIA request.
I know it is, but I mean, we
Yeah, I
can't
would.
ask for.
And remember, I would, if I were you, I would, you want the more, and I think that's good too. It helps the individual kind of think through, because sometimes the requests they give aren't that clear. but when you write things down, you think through it a bit more and give really what you want. So I always encourage that we would reach out to them, and to whoever asks you for something, say, well, could you send this in by email? So if possible, that's best. And we are working on implementing more standardized procedure. I think that's it's a difficult thing to do, but I think we've made good strides and we'll continue to do so. My goal would be that by the end of next year that you could ask how many FOIA requests have we received and be able to tell you, and how many did we respond to and what time frame did we respond to. That's where I'd like us to get to without having to pay the tens of thousands of dollars to buy a FOIA software, which we don't get enough requests to justify that. So, but we still have the exact same obligations whether we have that software or not.
So if someone comes up to me on the street and says, I want you to provide me with all the salaries of everybody that works for the county, I can say, that's fine, I don't have that information, which I don't.
Yeah, but
I'm not privy to it. You need to contact, you want to make the,
yeah, but it's still a FOIA request, and they give it to you because it is
I'm
information.
not acting in my official position. I might be shopping at
and
Kroger.
Yeah, and that really doesn't matter, because as an officer, an elected officer, or as an employee, when it says very specifically that they can make a FOIA request verbally, and so we can't be the ones to decide when we're in the capacity or not in capacity.
Right, but
they can call you.
Make it to anybody?
Yeah, they can make to anybody who is an employee of the county, and it's
So they
responsible.
could go to a lifeguard at the pool and say, by the way, I want you to do.
I don't know.
Well, but I know, but the way the law is written, it does not make an exclusion for that. We could argue that it's not. I mean, and I could come up with lots of creative arguments, because I gave Washington Lee $100 and something thousand to be able to do that, as to why that doesn't work. But it doesn't, in the statute, it does not make an exemption for it. So, I mean, obviously, I think it would be. This arguments would be stronger for a part-time lifeguard than it would be for a board of supervisor member or myself or Spencer. But yeah, if you receive any FOIA request, the best practice would be that you just send a quick email to Spencer or to me or to Heidi. Eventually it should get to Heidi. That's how the procedure should go. Time-wise, are we running so we can run through things? Okay, let me get through the last part fast.
Yes.
So we'll do our COIA stuff quickly. COIA, the purpose of COIA, I think you understand, is just to give trust in the government. You're required to receive, upon assuming officer, required to receive the COIA statute within 2 weeks of assuming office, and then you're also required to receive training within 2 months of assuming office, and receive training every 2 years after that. Things you're prohibited from doing is to use personal solicit gifts, receive gifts that are not legal, use infinite information for your personal benefit, use your public position to retaliate against anything else, or accept any business or professional opportunity that's supposed to influence you. This is a list of what gifts are. I won't go in detail on that since we don't have much time left, but it's written out there for you. So basically, don't accept gifts. There are some small exclusions, and there's a definition of what is and isn't a gift. If you have any questions about things like that, feel free to give me a call, and I can answer that for you. Your immediate family member, this also applies in large extent to your immediate family members, to particular issues as to whether or not you have a personal interest. Personal interest, generally think of $5,000. If you receive $5,000 in salary or $5,000 in benefits from a company that you own, or where you're an employee of that company, or from if you have personal interest in something, then that's would be subject to business in front of the county, where the personal interest is greater than $5,000, you would have a personal interest for purposes of COIA, and that would need to discuss with me whether or not you should exclude yourself. Immediate family means your spouse, no matter where he or she lives, and anybody, other person who's dependent upon you and lives in your house, whether or not they're a family member. There's two types of personal interest in a contract and personal interest in transaction. Personal interest in a contract is what it sounds like. If there's a contract before the county and you or another covered person, like an immediate family member, would tend to benefit from that contract, you generally should not participate in a discussion. There are exclusions for that, exceptions for that, and be like if you have a business and you can respond to an RFP, and that's perfectly acceptable. You can do that, though it's generally best that you would that you yourself would not participate in voting on that matter. Sales or leasing of real estate is allowed between you and the county if it's done all on an arm's length manner. And anything for contracts or goods or transfers less than $500, that's not covered by FOIA. Personal interest in a transaction means, for example, if you or a business you're working with has interest in some property that might be subject to a special exception request, then if it is a personal interest and you do not have an exclusion which protect you, you should not participate in any discussions or voting on that matter, and you should file the proper forms with the clerk with the clerk of the Board of Supervisors, and I can provide you those forms as I have for some of you in the past. There are certain exceptions to that. And one of the exceptions that's more broadly used is if you're a member of a business or a group or a profession which could be seen as receiving a benefit there, but it's a very broad and generalized group. Like if you're a member of the Rotary Club, and the Rotary Club has some business in front of the county. If that business doesn't pertain, for other reasons, pertain to you two personally, you could participate in the discussions and voting on that. However, you would need to make a disclosure and state that you do have a personal interest. However, you are able to participate in the voting and discussion on that matter, and that would be a form I'd have to prepare for you. If we only have 4 people in the meeting and one of you, say 2 of you have to step down because of a disqualification, the remaining 2 can still act and vote on matters, even pass ordinances and be treated as a quorum, because it just the removal of somebody because of a COIA conflict does not make it impossible for the Board of Supervisors to conduct business. You still can conduct business. And that's the only exception to the quorum rule that I'm aware of.
Down to one person?
It could be one person in theory. Yeah, they don't say that it couldn't be. So in that case, you could be king. Sorry, not a bad joke. Personally, there's certain the declarations you have to make around here, and these you need and make them orally in a meeting, depending on what the particular issue is, and it has to be done in writing and be provided to the clerk, and has to be preserved for 5 years. Your annual economic disclosures, as you know, have to be filed by February 1st. One of the issues I wanted to bring up is that the practice of the county has been to ask any members of any boards, commissions, authorities that you appoint them to require them to file what's called the short form disclosure. And we've been doing that. However, under statute, we are not required to do so. The language is that if the Board of Supervisors requires, for example, the library or the TCO, it requires those members to file the short form economic disclosure, then they're required to do so. We've been following the practice as though that's the case. However, we don't have any resolution or ordinance passed by the board that I've been able to find requiring them to do so. So I think that's a matter that my view on that is that we should no longer require that. However, if you do want those individuals who are not required by statute to file, then you should let me know. We can create we can create some sort of ordinance or for you to go ahead and pass to require them to do so. So as of now, I think in the future we won't. If there's no action by the board, then only those who are members of the EDA, are members of the Board of Supervisors, or those of the Planning Commission, the Board of Zoning Appeals, and the county administrator who are required to file real estate disclosures will be the ones that have to file the disclosures. But I can provide you more information on that if you have questions. One thing to keep in mind, failure to file these by February 1st, whether you're the EDA or the Board of Supervisors, There is no out on this. It has to be a $250 fine, period. And we're required by law to notify the court of the Commonwealth's attorney if the $250, if it was not filed on time, and the individual who failed to file on time has to pay. There's no, and it's very clear, has to pay the $250 fine. So it's important that we get that done in time, which I believe all of you have, and that's not been an issue. So for violation of the COIA, civil and criminal penalties apply. It's a misdemeanor. In other words, crime for willful violations. And this is enforced by the Commonwealth's attorney. Your protections are to seek, you can seek an opinion from me, and that opinion that you receive from me could be used as a defense in court if the Commonwealth's attorney brings a claim against you, as long as you revealed the facts clearly. And then if you receive an opinion from the Commonwealth's attorney, then he or she are not able to bring a case against you, period, even if it turns out that their interpretation was incorrect. Just basic things here. And this our COIA procedures that I'm a resource to you and to any of the county employees and other board and commission members. The clerk of the board is responsible for gathering quite a bit of information, especially the economic interest disclosures. And we are discussed who does have to file disclosure and who doesn't. So are there any questions?
No, maybe we can save these for the next training that we do, or for our citizens that might have.
I think that's a good idea. And in the future, if we do training, the purpose of doing, and we can discuss how often you want to have this. If we do it annually or biannually, would probably make update. There's occasionally changes in the law, and so we just update that. All right. Thank you very much.
Our regular meeting will begin at 5:30. We have a 5-minute break. Well, I suppose, excuse me. Is there a second?
All right.
Okay, Mr. Day. Yes. Mr. Daniel.
Yes.
Mr. Lewis.
Aye.
Mr. Lyons.
Yes.
And I vote yes.
For the record on the video, I just muted that, so that was a motion to adjourn and a vote.
Welcome to the Monday, February 24th, 2025 Board of Supervisors meeting. This meeting is now called to order. Ms. Whitten, will you conduct roll?
Supervisor Lewis.
Present.
Supervisor Day.
Here.
Supervisor McDaniel.
Here.
Supervisor Lyons.
Here.
Chair Ayers.
Here. We will now offer an invocation followed by the Pledge of Allegiance. Those attending are not required to participate, but if you'd like to join us, please stand.
Dear Father, we come to you humbled and grateful for your blessings. Thank you for the precipitation this winter that has replenished our water sources, and we thank you for the drier and warmer weather this week. We pray for you to help and heal those in our community that are sick or ill, and we ask for your leadership and guidance in conducting the business of the county. Amen. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
We will hold citizens' comments near the beginning of the meeting. We will do our best to take citizen comment remotely. There are two options for citizens to offer comment. To join by telephone, you may dial in on one of the numbers listed on the county website. Webinar ID and password are there for your convenience. Citizens wishing to simply view the meeting live or after the fact can do so on the Rockbridge County Board of Supervisors YouTube channel, also available on the county website. If you wish to make a citizen comment as a Zoom meeting participant, you will use the raise your hand feature. You can press the raise hand button on the bottom of your Zoom window or press *9 if you are calling in by telephone. Are there any changes to the agenda?
No, ma'am.
Are there any citizens signed up?
No, ma'am.
Okay. Are there any online?
Nobody with their hand raised.
Is there anyone in the audience that would like to speak? Offer citizen comment? So it's a good time. If not, we will move on. Approval of the minutes. We have 3 sets in front of you. Thursday, January 16th, Monday, February 3rd, and Monday, February 10th. Gentlemen, you have reviewed those. Are there any questions or comments? We will do them all at once.
So I suggest that I make a motion to approve the
Okay.
minute block.
Thank you. Do I have a second?
Second.
Mr. Lewis,
Aye.
Mr. McDaniel,
Yes.
Mr. Lyons,
Yes.
Mr. Day, and I vote yes. School appropriation resolution, Mr. Harrison.
Yes, for the schools, they have total appropriations to Fund 50 in the amount of $90,071. The first is a donation towards CTE equipment in the amount of $14,000. And the second one is a grant, $76,071, and that's capital related expenses for school safety and security.
All right, Mr. Harrison. Is there any questions, comments?
Make a motion to approve the resolution.
Is there a second?
Second.
Mr. McDaniel,
Yes.
Mr. Lewis,
Aye.
Mr. Lyons,
Yes.
Mr. Day, and I vote yes. County financial report and appropriation resolution, Mr. Harrison.
Yes, before you is a resolution requesting the additional appropriations and the payment of bills. The total bills this period is $113,198.65. The two appropriations we're requesting is $12,274 and CSB overtime reimbursements for the sheriff's office and $26,468,000 in fire program grant funds. We do have the thank you to the board for your flexibility in doing the budget meeting too. We do have the real estate and personal property tax information. We'll be meeting with the finance committee is meeting this Wednesday. So that's timely so they can work on some other issues before that first meeting with the second budget meeting with the board. We're having our kickoff meeting with Tyler Technologies this Thursday, and that'll involve all the functional leads. It's just introduce all the players so we can get to who is going to be our leads on Tyler's side, and they can see who all the relevant people are on our side. The schools are also participating in that as well. And there'll be a second meeting, and that's more technology focused with the IT departments for the schools and the county on how to set up the system, the software stuff. And so that is good news. And that's all I have at this time.
Thank you, Mr. Harrison. Questions, comments?
Make a motion to approve the resolution.
Thank you, Mr. McDaniel. Do I have a second?
I'll second.
Mr. McDaniel?
Yes.
Mr. Day?
Yes.
Mr. Lyons?
Yes.
Mr. Lewis?
Aye.
And I vote yes. Consideration of farmer's market application, Virginia Gold Orchard Holdings LLC. Mr. Slade.
Thank you. Miss Tiffany Ice has submitted an application for outdoor events to hold a farmer's market per Chapter 4 of the county code, of course. That would be the amusement and entertainment section of the code, Section 5, farmer's market. Property is located at 55 Asian Pear Way, Natural Bridge, Virginia. The property is owned by Virginia Gold Orchard Holdings, LLC, care of Thomas Van Diver, 100 Asian Pear Way, Natural Bridge, Virginia. It consists of 29.38 acres per tax records. This, as you know, is the first farmers market associated with the property. Per the enclosed application, the proposed farmers market will be held on each Saturday from 9 a.m. to 12 p.m. Starting on April 5th, proposed start date on April 5th, 2005 to the end of October or the beginning of November, depending on the weather. With that, I'd like to have Miss Ice come up and Mr. Van Diver, excuse me, and their team, if they'd like, to just explain the application in greater detail. And if needed, I have the reference site plan in there. So
Welcome.
Hello.
Hello.
Thanks for having us.
Good to
Thank
see
for
you.
having us.
Tiffany, you can talk about the market, and then if there's any questions about the property, like as a host site.
Okay.
And if you all can just make sure you're talking right into the mic.
Sorry, I wasn't really prepared to speak, but no, we were just trying to, we've been looking for a good location to host a farmer's market. Kara and I actually are the people that will be running the market. We both have experience with, other local markets as well, but Natural Bridge has been lacking. And we came across their orchard and thought it'd be a perfect location. It's out of the way. It's great for, it's easy access. We'll be hosting, local farmers to have an opportunity to be directly to the public, and we're really excited about it.
And the vision is for it to be a producer's market. So
Yes,
that
yeah,
folks
it
that are
will
growing
be.
stuff Locally. at their
Locally,
own
yeah.
farms, selling it to the community. Obviously, the hope is that tourists will appreciate it as well in season, but that it will be an asset not just for people from Door County, but folks who live anywhere in the county, but especially towards the southern end, and give producers, who are in the county, an opportunity to sell their wares as well.
So there'll be tents and that sort of thing. Well, I'm sorry, it's probably in here. Does the applicant or the farmers bring their own tents, or is that something that will be kind of built in?
Yes, the idea is that we have a space that's it's nice and flat, it's graded, but that each vendor would have their own tent. It does, we talked about that a little bit, it does kind of add a flair to it. See all the different shape and size tents. It's something that gives it more of that farmer's market feel. All of them, of course, will be weighted down from a safety perspective. The area is very windy, but yes, the idea is that everyone will have their own kind of little booth set up.
There are rules and regulations for each vendor coming in, and part of that is, yes, you bring your own equipment, your tables, your tents, and everything does need to be weighted down.
From a facilities perspective, obviously the bathrooms at our commercial location will be open during that time for guests to use.
That's good.
How does this interact or impact the farmer's market that's already in Glasgow on Saturday mornings?
The distance away, I think there's plenty of distance between, that's, Lexington has theirs, Buena Vista has theirs, Glasgow has one, but people out in Natural Bridge don't really have, easy access. Glasgow is a little bit further away than the location that we're looking to set up.
So will there be an application process?
There is an
You mentioned there were
application
rules and
process.
regulations. Is there
Yeah, yeah,
also?
there's just rules and regulations because we don't want, people coming in with like resale items. There's no resale items and, it's local producers, and all the safety, measures that they need to take weighing down your tent. There is an application process.
David, to your point, just comment, there's one in Fairfield and one in Rafine, and those have, it's sort of a all boats rise as I see it. People generally go to both.
Well,
Yeah.
that's one of my concerns. I mean, I fully support your application. Don't. But we've seen a growing number of these throughout the county, which is great. But I'm afraid that it's also putting a strain on the farmers. Where do I go? Or the customers, where do I go? Do I go to Fairfield? Do I go to Goshen? Do I go to Glasgow? I don't know what the right number is or the right locations. And I think from a community standpoint, we need to do a better job of kind of aligning these with a point in time. There's 7 days a week that could be operated. They don't all necessarily need to be operated Saturday morning.
Well, that's actually why we did it on Saturday, because I know that the other markets, it doesn't conflict. So it'd still give those same farmers an opportunity to get to a different customer base. Like, Lexington's on Wednesdays, Buena Vista's on Thursdays. And I know Glasgow is Friday, Saturday, Sunday, but correct me if I'm wrong, but I think it's at a different time because we're Saturday mornings. But I did want to make it in a time where it's not conflicting with other markets. So those same vendors would have, access to new customer base.
Anything else?
I don't have anything for that. I have a question for Mr. Slayton when he comes back up. What, from a community development standpoint, what are we doing, or how can we help with all the different farmer markets that we have going on, and that they don't take away from another one that's already in existence?
Currently, of course, we've approved one in Fairfield and one in Rafine, one in Carrs Creek. With that being said, if I recall correctly, Rafine and Fairfield work together, two landowners, I should say, work together not to have conflicting dates. With that being said, of course, we're not part of the Glasgow's approval, so I'm uncertain on when
Friday
held.
afternoon, Saturday morning.
Okay, Friday afternoon, Saturday morning. So I was unaware of that until just now, essentially. But I do agree with Jay's comment, Supervisor Lewis comment as far as the Rafine Fairfield, the distance away. But again, they did not have conflicting schedules. So some of that's just going to be, the capitalist society we live in, and who rises to the top, and where do farmers go? And then therefore, where do the consumers go to get the farm goods? We have started. I got just this afternoon, I got all the lists from Brandy. So Miss Whitten, so I can prepare the ones we know about. I could, of course, can look into Lexington if needed, but I can get a list going on. Of course, this one will only be for 1 year, and then they have the ability to apply for a 5-year permit next year. And so the one in all three of them, what we previously approved, again, Rafine, Fairfield, and Carrs Creek, all have currently have a 5-year permit, or when it was adopted, I should say.
Yeah, I think, again, I think it's great for our farmers to have a place to go to sell their goods. I think it's great for the landowner to be able to set this up. I think it's great for consumers to be able to buy local. I think all of it's great. It's just when we start competing against one community against the other, I think we can do it a little more logically than everybody having it on Saturday night, across the county. So.
And one thing we could do, I mean, this is unusual because it's aside from zoning. Obviously, it's in the county code. Historically, we've shepherded these applications. Happy to do that, of course. But one thing on the zoning side, I always think of, you could make a proposed amendment, go through the public hearing process, obviously, amendment to the county code to prohibit two farmers markets competing within a 5-mile radius or whatever square miles. But that's currently, to be clear, that's not currently in the county code.
more and more people are going to these markets, and the beauty of the market is that it's your neighborhood market. So that's the goal, is to get the people in that community to support their farmers market. So
Sure.
I understand your concern, but also I'm not so worried, because I think the movement to buy fresh food close to you is moving on. I mean, I think that's happening, and I think people will buy wherever they can get it at this point. So that's just my feeling here. Anything else?
Again, this one per code would be for a 1 year permit.
And are there any other questions, comments? Okay,
I'll make a motion. We approve for 1 year.
sir. Mr. McDaniel?
Yes.
Mr. Lewis?
Aye.
Mr. Lyons?
Yes.
Mr. Day?
Yes.
And I vote yes. Thank you. Good luck.
Okay. Thank you.
Review of the Natural Bridge Drag Strip Annual Report.
Yes, per condition number 1 of the special exception permit, the Natural Bridge drag strip is required to present an annual report to the Board of Supervisors. The report is supposed to be presented to the Board of Supervisors prior to the second meeting in January. Historically, the board has allowed the report to be presented at the second meeting in January, and sometimes that leads into the February cycle for the Board of Supervisors. Mr. G.W. Fitzgerald, the manager of the drag strip during the 2024 racing season, is here. Of course, the purpose of the annual report is to review conditions, how they were met in the prior season, provide y'all with start and stop times with the prior season, and present you the draft 2025, in this case, the 2025 schedule. So with that, I'd like to turn the floor over to Mr. G.W. Fitzgerald, again, the manager and promoter of the 2024 drag strip season.
Good evening.
Well, anyway, last year we got a late start, but we got started in the end of August. And it turned out good. People was really excited and had a lot of people donating time, free time, because it hadn't been run for so long, been down for 5 years. So anyway, we started like I said in August. Let's see my times. That's the start time. Yeah, well, all of them, like that one started 12 o'clock and ended at 6. You have to start it by 12 o'clock on Saturday. And on our race times, the same way. We started at 12, finished at 6:15. And you have one in Test and Tune. We started at 5 o'clock and ended at 9. That was on a Friday night. We only had actually 3 races this year because it's such a late deal. I didn't even get the timing system put in all the way. We had the it was never started before 12 and never run past 11. And no engine was ever started before 12 o'clock. The roads was always watered. Most of the dirt track people watered the roads for us. And the EMT and Goshen, I had Goshen Rescue Squad there on a contract for all the races this year. I couldn't get anybody else, and they finally come through for me. They're going to do it again this year too. And the trash was picked up on the same day within 24 hours. And we've got a line fence between the drag strip and the Flint properties and behind us, because that has to be maintained. And then, of course, existing tree screens remains the same between the drag strip and the Flint properties. Safe hold risk is my insurance agent that provides my insurance coverage. And the event schedule for the drag strip is mostly on Saturdays this year. Does include some Fridays, but I don't think there'll be many. And the drag strip will not run on the weekend. The fair, I had it on the schedule, but I didn't really know what day the fair was, so I took it off 13th. Let's see. There was no new bleachers or nothing put on the property line. And CNS disposal will provide the dumpster. And during the 24 race year, property improvements were made. It wasn't a lot, but mostly to the buildings and stuff there. And then all races on Friday require participants run with a muffler. The 2024 event season ran from August 17th to November 30th. We didn't run but one race in November, but I think it was 26 degrees that day. But anyway, we ran. And there'll be no jet turbine engines were run there. So that's pretty much the way it is. And hopefully we get started in March this year and have a better year, or, you know, full year anyway. Sure. Everybody was really, really gung ho for it. I mean, I had a lot of happy people this year. No complaints and all. So,
Okay.
other than that, that's really it.
Okay.
You said that there would be some Friday events?
Yeah, I don't have them on the schedule, but on a Friday, it's just a test and tune, but we have them. But I don't think I have any on there.
I
at
didn't
all.
see any on there.
Yeah,
We
so-
need to know those dates.
Do,
Yes. So when residents call, we can explain to them that it is.
but it's always run on Fridays, but I didn't know what kind of input I would have on Friday nights. I just didn't do it. Just figured I'd cut it down some, but
Yeah.
I can put the dates on there. If I don't run, I don't run, right? I mean,
That's essentially what the, if you may recall, last month, the Speedway did their annual report and they made the similar request. They put a lot of practices, I think, if it wasn't regular racing schedule, they put a lot of practices on there. Per condition number 11 of the drag strip, the permit holder agrees that the drag strip may be operated on Fridays and Saturdays as set forth above, and above has some time restrictions there, and no more than 3 special event days. So they do have the ability to run Fridays and Saturdays.
Did you have any, because I received a couple phone calls, I'm just asking questions.
okay.
It was that you had, or that there was one car there some days running that when there shouldn't have been any event going on.
Well,
What's the
no,
deal
it
with
was
that?
Guy up there, I got a machine shop and I build motors for people, and I built the guy a motor, and he just wanted to try it right on the line. He never run it. He didn't do anything. There was no race or anything going on. It was a day that we was just up there. And matter of fact, the law came and they said, you know, they seen I wasn't racing or anything. I actually watched him do it. He was going to race in Columbia Beach the next day, and he wanted to try it out, do something right on the line. So we went like 60 feet, and that was it. And backed up and did it again. Did it like 3 times. But I got a phone call when I was going in the gate. Right when I went in the gate, Carolyn Johnson called me, because I know her and Dr. Jake. Anyway, she called me and asked me if I knew somebody's up there. I said, yeah, I'm pulling in right now. Actually, the boy worked for me. But I said, I'm going to take care of it. So I went up there, but by that time, somebody had called and they came up and talked to me. And actually, at the same time, my tower then got broke into, and I had a sheriff come here and do a report on that. They kicked my door open and didn't steal anything or do anything, and just kicked the door in. So he went up there and did all that while he was there. But yeah, it was no race though. There was no event, nothing going on. I mean, November 30th was my last day, and that was the day it was like 26 degrees.
Okay.
And that would be probably, if that happens again, that would be problematic per the permit as far as essentially any racing activity. It's condition number 2 states the racing season shall be from March 1st through November 30th of each year. All events and racing at the Natural Bridge drag ship shall be within this time period. And so that would include, in my opinion, without looking further into it, that would include practices, as we talked about, you know, with the Speedway. They would be considered a special event, even a test and tune, something like that we're speaking of.
And the only other question I had for you was, I had some people who were concerned about, and you said that there was always an ambulance
Yep.
with EMT on.
Every race, Goshen Rescue Squad. I got stuff where I paid them and all, got the receipts. But yeah, that's on people have to get.
And to the permit, Mr. Slayton, can you speak to what ambulance is, what's required of that?
Sure. So I might be able to actually find the letter. So the condition number Bear with me here. Condition number 6 states the permit holder will have adequate certified emergency medical, EMT staff, and security staff at all events and strictly enforce no parking on the state maintained road. I can tell you the exact date, but it was probably after your annual review last year. But as y'all may know, I made that determination. This states adequate certified emergency medical. So as the zoning administrator for the county, I had previously made the determination of what adequate certified emergency medical staff is with the drag strip. I'm sorry, with the speedway. That's when the drag strip was not operational. And so that determination was not made until they started racing this year. Of course, wrote the landowner of the property, Porter Jones LLC, I believe it is. And that is an appealable. It could be that could have been appealed. That zoning administrator's decision could have been appealed to the Board of Zoning Appeals. It was not, so it's standing. And essentially, what that states is it's an adequate certified medical staff includes a basic life support ambulance as defined by, and I might look to Mr. Suter. Do you remember the national
BLS ambulance with crew?
With crew, and
Yep.
so it's as
So it doesn't have to be ALS. So
yep, and what that means, and bear with me here, I can probably find it pretty quickly.
it's just it's a ALS is advanced life support. This
So-
is just go ahead.
It's having a basic life support. It's been determined that this letter was written and mailed on August 22nd, 2024. And it's been determined that adequate certified emergency EMT staff includes at minimum having a basic life support ambulance, BLS, permitted by the Virginia Office of Medical Services on site during all events. It's my understanding through conversations with Mr. Suter and the Chief Ramsey that includes not only obviously having the ambulance on site, but it also includes the driver for the ambulance and a paramedic associated with it.
That's the way they.
So that's what would be defined.
Not a paramedic, I don't think.
EMT, excuse me.
Yeah,
EMT.
yeah.
Sorry.
EMTB.
EMTB, excuse me. Pull that up.
Yeah, they were there. I had a hard time finding somebody. I tried to even get private for a while, and then finally they come along for me. I'm so glad because they always came. You know,
But if they don't come, is that you,
No, I can
you
run.
can't run, you can't run. Correct.
okay.
All right.
They got in traffic one time on A1. I didn't think he was gonna make it, but they made it.
We appreciate you looking around and using some of our county agencies.
I tried though. I tried. Glasgow, of course, they doing the dirt track and couldn't do it. And I tried Buena Vista, tried everybody, even private. Like I said, I couldn't get them. You know,
Are there any other questions, comments, Mr. Fitzgerald? No? Not, is there a motion to accept?
I'll move that we accept and hope you have a good season.
I hope so.
Okay, is there a second?
Second.
Mr. McDaniel?
Yes.
Mr. Lewis?
Aye.
Mr. Lyons?
Yes.
Mr. Day?
Yes.
And I vote yes. Update on the CSPDC housing study. Ms. Flint.
Chair, member of the board, thank you for an opportunity to provide an update on the recently completed housing study by the Central Shenandoah Planning District Commission. Tonight, I'm not going to go through the full report, but I will give you some key findings, recommendations, and our next steps as outlined in your agenda package. For the Rockbridge region, including both cities, the study identifies several critical challenges, one of which is the shortage of affordable housing inventory, shifting demographics that will impact housing demand, a growing need for workforce housing as businesses expand or move to the area, a pressing need to invest in infrastructure to support additional housing development, therefore increasing supply. And number 5, a review of our land development regulations, which was conducted by Housing Forward as an add-on to the housing study for us, which resulted in some recommendations for regulatory changes. I've shared this information with Mr. Sladen, so we'll work together on that. To encourage investment in housing, we are organizing a regional housing summit this fall in partnership with the cities and the Chamber of Commerce. This summit will bring together both key stakeholders, businesses, realtors, developers, community leaders, and more to advance regional housing solutions. The full housing study is available on the economic development page on the county website, as well as on the CSPDC page. If you would like to review the full report, which of course is for the CSCDP footprint, we have specifically pulled out the 2 county sections on the website to make it easier to navigate. Before I close, I want to leave you with a quote that I heard some time ago. Workforce is the currency of economic development. If we want to sustain a strong workforce, we must ensure access to both affordable housing and childcare. In that regard, I wanted to let you know that my office is working on a strategic plan for childcare based on a recently completed needs assessment. And we're formulating a strategic plan. I will provide you additional information with regards to that study as we move forward with that strategic plan at a later meeting. But the data is available on the county website under the economic development page. And I'll take any questions you may have.
Thank you for working on the summit. I think that's obviously good. From PDC information, there's some precedent for that. There was one in Harrisonburg that some of our people went up to. So I know we have folks who are actively interested, and hopefully we'll have good participation in that summit.
Stanton, Augusta, and Waynesboro held one as well, and it was successful in making partnerships that have resulted in a couple of developments moving forward. So.
I would recommend that you work with Mr. Sladen and county officials. Last year, I believe, at a National Housing Summit study, whatever I was at, it was revealed that the average house today built has approximately $90,000 of regulatory cost in it. So anything we can do to help streamline that, and because that is
Local regulatory?
that's on a national level.
Yes, sir.
But the point being, it's just a lot of regulatory involved in the home building process, and anything that we can do to help streamline that would help with our supply.
Made a note of that. Any additional questions? Thank you.
I will say that locally, I think any developers and contractors would give our building department some pretty high marks on making good common sense decisions while staying within Boca. So
They definitely streamline the process. Thank you.
Consideration of readoption of regional library agreement. Mr. Suter.
yes, this item is noted in your package is intended to clean up an oversight regarding the Rockbridge Regional Library Agreement. The partner localities, which include, of course, Rockbridge County, Bath County, and the cities of Lexington and Buena Vista, adopted an agreement back in 2019. All approvals anticipated the execution of a lease agreement for Goshen Library, and that was listed as an exhibit in that agreement. And we were thinking that was coming pretty soon after that. We were just going to attach it and move on. Ultimately, that lease never materialized, and a lease for a new space was finally executed all the way up into 2022. By that time, I'll take the blame for this, but I don't think any of us were really thinking about going back and reattaching it to that. And it wouldn't, by that time, it wouldn't have made a whole lot of sense having a lease agreement that was from 2022 on an agreement from 2019. So this recently came to light, and after discussion with Mr. Dryden and the managers in our partner localities, and also Ms. Goyette, who is here tonight, executive director of the library, and also recognize Harper Bryan, who I believe is chair of the library board, is here with us tonight. Everybody determined that the best thing to do would be to readopt this agreement, or recommend readoption of the agreement. There really are only 3 changes to the agreement from what you originally adopted and what's before you today. The dates obviously have changed. The names on the library board members, all of those have, I think almost all of those have changed, if not all, and they were listed as Exhibit B, I believe. And we now have a Goshen lease, as I noted before, to attach as Exhibit A. And so the request is to adopt the resolution in your package, which would consummate the agreement. And the other partners, we believe will be taking this up within the next 30 days in their upcoming meetings, either later this month or in March. And we put an effective date of April 1. It fits nicely right on a quarter. And my only request is to include in your motion of adopting that, if you were so inclined to do that, that this is subject to approval of all parties adopting.
Absolutely. Comments, questions? Not, we're looking for a motion to adopt the proposed resolution.
Move that we adopt the proposed resolution, pending the adoption of all parties involved.
Thank you, Mr. Lyons.
Yeah.
Mr. Lyons.
Yes.
Mr. Lewis.
Aye.
Mr. McDaniel.
Yes.
Mr. Day.
Yes.
And I vote yes.
And there's a library in Goshen.
Yes, there is. Consideration of updated VADI broadband grant agreement with Brightspeed.
I'm sorry to keep bringing you all broadband things, but it's just
Okay.
the lay of the
As long as it's
land.
good news.
So in December, I provided the board with an update on body grants the county and its partners procured last year. Please recall that due to a federal USDA grant in the Carterstown area, Bark Connects was awarded a grant for the exact same area that was part of the Brightspeed body grant. Bark had submitted that grant prior to the first one, and DHCD, Office of Broadband, opined that Brightspeed needed to pull back from that area so as not to spend both federal and state dollars in the same area. So Brightspeed pulled back, and as I reported at the time, they were trying to rescope the project and find other areas in the county where they could reach with and continue on with this grant. And let's see, backing up just a little bit, recall that the board had previously dedicated ARPA funds as the county's grant match. And that occurred both in the 2022 application where we were unsuccessful and the 2023 body application, which we were successful in. And a federal requirement was that ARPA funds, and this is on the federal side, on the ARPA side, not only had to be dedicated, but under contract by the end of 2024. Now, keeping in mind the timing of this, we found out in basically late October that we were going to have to rescope this. There was no way to get a contract in front of you by the end of the year. So what we did in order to obligate those funds, we shifted those funds to pay for the recently completed Natural Bridge Elementary School HVAC project, thus freeing up the general funds that were going to be used for that project to then be used as match for body projects. And your package contains an agreement with Brightspeed, which is required under the body grant award. And this was just completed. This is a fast moving train. It was just completed last Thursday. So as not to let any grass grow on this, or moss grow on this, I want to get it in front of you so that Brightspeed can continue moving ahead. So it is in review with Brightspeed right now. Their attorney's been out of the office. I have no reason to believe that since they've been involved through this whole process, they would have any substantive changes to this. My request today is really twofold: to approve the agreement authorizing staff to make any non-substantive changes should Brightspeed have any, and then also to officially redesignate expenditure of $1,774,300 now in general fund dollars toward this grant match. I need to have the vote for that to give it to body to guarantee that the board is all in. And the next step in the process would be to execute then an agreement with DHCD, Office of Broadband, so that Brightspeed can continue to move on. They're working now. We just don't have a grant agreement set with DHCD. I'm sorry if any of that was
But that
confusing.
part is not part of what you're asking for today.
No, that is not.
All right, gentlemen,
I move we approve the agreement and dedicate the $1,774,300 in general funds grant as a grant match, replacing the ARPA funds.
thank you. Do I have a second?
I'll second.
Are there any questions? Anybody ready? Mr. Lyons?
Yes.
Mr. Day?
Yes.
Mr. McDaniel?
Yes.
Mr. Lewis?
Aye.
And I vote yes.
Thank you all. Try to
Consi-
keep away from broadband for a little bit.
Thank you. Consideration of contract with virtual IT.
The county staff has presented to you a contract with Virtual IT, which is the entity which has been providing technical consulting services with regards to our ERP system, which we entered into with Tyler. They support us in the negotiation of the Tyler contract. However, their contract for the period of time for the contract we had previous to them has expired, and using the Campbell County cooperative procurement process, they're under an RFP issued by Campbell County. We went ahead and negotiated another contract with Virtual IT. And so the contract we're bringing for you is a contract for $122,760 estimated cost for providing the support from the dates of the contract from January 1st of this year until October 31st of 2026, which is to support us in the implementation of the Tyler contract.
Right. Any questions for Mr. Dryden?
I move that we approve the contract.
Second.
There's actually a resolution we prepared.
The resolution that is with it.
Thank you.
Supporting the contract.
Second.
Mr. McDaniel?
Yes.
Mr. Lyons?
Yes.
Mr. Day?
Yes.
Mr. Lewis?
Aye.
And I vote yes. Consideration to set public hearing to amend county code regarding county decals for farm use vehicles. Mr. Dryden.
So this is another issue that's brought before you again. As you recall, last year the Commonwealth implemented a law requiring that all farm use vehicles or certain farm use vehicles register with the DMV. In the past, those vehicles just went into Tractor Supply and bought a farm use tag, which they put on their vehicle. That is no longer allowed, and they, as of July 1st of last year, were required to register. Because they were required to register in the way we wrote the way our county code was written, they would have had to pay personal property tax on those vehicles if we did not change our county code. And so last year, we went ahead and changed the county code to exempt those vehicles from personal property tax, given the fact that they were not taxed prior to that anyway. It was recently brought to my attention by the county treasurer that the county code with decals also has similar language requiring that any resident of the county with a vehicle that's operating in the county is required to and that is required to register that vehicle with the DMV is required to purchase a county license decal. To avoid this from being an issue, and under the county code, as you well know, the cost is $25 and it's a one-time $25 fee. So it's not a particularly large number of vehicles that this will impact. However, if there's not a change to the language of that ordinance, then the farm use vehicles who registered with the DMV will be required to buy a decal. So the proposal is to set a public hearing, since it's an ordinance, schedule a public hearing, and for the purpose of considering whether or not to amend the county code to exempt farm use vehicles from the decal obligation.
Thank you.
You speed read that?
All right, is there a motion to schedule a public hearing?
I move.
That's where the date would be March 24th.
On March 24th.
I need to clarify that, Mr. Dryden.
I think that's fine. Sorry. Good.
I'll second that. All right, Mr. Lewis,
Aye.
Mr. Day. Yes. Mr. McDaniel.
Yes.
Mr. Lyons.
Yes.
And I vote yes. Board, do you have any other comments or unfinished business? Report of your committees? Not, just a reminder that the board has a meeting scheduled for next Tuesday, March 4th at 6 PM at Virginia Horse Center. This is a joint meeting with the Planning Commission and Solar Committee to discuss the draft solar ordinance. Additionally, and depending on the latest information available on budget revenues, the board may hold a called meeting sometime next week to discuss FY 2026 budget. If the meeting is called, it will be properly noticed. There's nothing from anybody. Is there a motion to adjourn?
So moved.
Second?
Second.
Mr. Lewis?
Aye.
Mr. Lyons?
Yes.
Mr. McDaniel?
Yeah.
Mr. Day?
Yes.
And I vote yes. Good evening.